I'm going to talk a bit about conscientious objection in euthanasia legislation. And bearing in mind the question, so the question of this workshop is, what makes a good euthanasia law? So my question will be, in what way any conscientious objection clause might make euthanasia laws good or better than they would otherwise be. One point I would like to start from is that when we talk about euthanasia, and we also heard the previous talks, we tend to frame the discussion as some tension between things like self-determination, dignity, right to die on the one hand, and on the other hand, things like the value of human life, for example, or concerns about slippery slopes, concern for people with disabilities, which we'll hear about later today. And this is good. This is a lot of what euthanasia laws are about. But one thing that this type of discussion is missing is the fact that euthanasia laws are also laws about the role of the medical profession. So a euthanasia law is a law about what medical professionals are allowed or sometimes obligated to do or not to do. And this aspect, I think we risk missing a lot of the discussion if we don't take this aspect into account, because as came up earlier in conversation, so there are already laws around suicide or assistance in dying more generally. But what we are talking about is how the medical profession gets into this picture. So one question is whether, so what role the medical profession should have in a good euthanasia law? If I'm assuming there is such a thing as a good euthanasia law. So what is the role of the medical profession? And ideally, it seems to me, a good euthanasia law is a law that is consistent with good healthcare. So you want whatever counts as good healthcare, good health practice, to be consistent with the law. Because often these two things don't go together. You can think of examples in another context, but a good law is a law that follows good healthcare. And I want to talk a bit about the relationship between these two things through the lens of conscientious objection. So conscientious objection is, people will disagree about what exactly falls into this concept, but conscientious objection broadly is the idea that there should be conscience-based exemption for certain healthcare professionals from performing certain procedure. So there has been a lot of discussion, of course, about conscientious objection in the case of abortion. But of course, a similar problem arises in the case of euthanasia laws or any law really is about controversial issues. So conscientious objection is often framed as a matter of freedom of conscience, of course. Now, so having said that, a good euthanasia law is a law that is consistent with good medical practice. The other question is, how does conscientious objection fit this picture? What should we say about the conscientious objection? So should a euthanasia law include a conscientious objection at all? Some people might ask. Because also in the discussion earlier, we heard that, of course, no doctor should be forced to perform euthanasia or to assist with providing medical assistance in dying if they don't want to. And that's something that's often taken for granted. And even activist organizations say, yeah, doctors don't have to do it if they don't want to. So, yes, that's what I will to say something about that. I will say something about that. So there are two reasons why we might think that conscientious objection makes a good euthanasia law. One is that it's a good compromise, some people will say. And the second one is that it respects freedom of conscience. So if you think these two things are important, then you might think that a good euthanasia law would include protection for doctors' conscience. So let me say something about the first point, so compromise. So conscientious objection in any legislation about controversial procedures is often seen as a good compromise. And indeed, historically, that's how conscientious objection was introduced in medical legislation with the case of abortion. So when abortion was decriminalized in the US in the 70s, conscientious objection was used to make by and large, to make the law, abortion laws in different states more politically palatable. So, because the practice was very controversial, of course, and still is, of course, for obvious reasons. So, conscientious objection is something that makes, is a kind of compromise. Now, the term compromise can be sometimes a bit misleading because, of course, there are at least two meanings of the term. So, in one sense, a compromise is something that is suboptimal, not ideal. So you compromise on certain value, a certain principle, and you have a law that is a bit less good than it could otherwise be. So it's a kind of compromise, suboptimal. And compromise, like when people say, I'm compromising on my values, on my principle, and I'm doing these things instead of doing this other thing. This is one sense of compromise. And it is a sense of compromise as in meeting halfway. So you have two different views, two opposing views. For example, euthanasia, some people are in favor, some people are against. So we have a law that, for example, allows euthanasia in the same way as some laws allow abortion, but also allows doctors who don't want to be part of the practice to be exempted. So that's another type of compromise. You meet halfway. And compromise in laws, I take it, is usually a good thing, but what we don't want is to transform this sense of compromise into the former sense. So to make a law that is suboptimal, not ideal. So we don't want to compromise too much, at least on moral principle, moral values. But we might want and actually need to compromise on, in the political sense of the term, so meet halfway. Now, you might think that if you want to introduce a euthanasia law, this sense of compromise, like meeting halfway, is the easiest way of doing it. Because it's easier to get support from, not just from the public, but from the medical profession, for professional organization. If you say, we think this should be legal, but we're not saying that every single doctor should be forced to take part of it. So I don't know about the value of compromise in this context. So if you are in favor of euthanasia and you think this kind of compromise is the way to get a euthanasia law passed, approved, then that's fine, I suppose. But then there will be many people who are not in favor of euthanasia. So I'm not sure to what extent this argument would work with them, because for some people, even this kind of compromise will not be good enough. So if you think euthanasia is morally impermissible, what probably you want is that it is prohibited to court. You don't want any compromise on that. So, but that's one reason why conscientious objection might make a good euthanasia law. Now, the other reason I mentioned earlier is freedom of conscience. So protection of healthcare professionals' moral principles, all religious principles, moral values. And some might say, well, of course, a good law is a law that accommodates freedom of conscience. And that's, to me, is interesting because, first of all, I'm not sure that that's what a law should do in all cases. But the other thing is that, so if you legalize euthanasia, I said earlier, is about saying something about the nature of the healthcare profession. So you might want to say that if a patient meets certain criteria, then the medical profession ought to provide this service to this person if the person autonomously asks for that. And then there will be different criteria for that. Now, if there is this obligation on the profession, then first of all, there is a question about whether the obligation is on the profession as a whole or on individual doctors. And the answer to that question might be a bit complicated because, well, for one thing, doctors take on professional duties and responsibility when they become doctors. And these duties and responsibilities usually are the same for all professionals. And secondly, there will be a problem with creating the circumstances where you cannot control how many doctors would object. So I come from Italy, for example, and if you think about the abortion legislation in Italy, so abortion in Italy is decriminalized, so women can have abortion up to a certain point and different criteria, but doctors can object. So you have some areas of the countries where you have as many as 90% of gynecologists, who are the ones that are authorized to perform abortions, that are conscientious objectors. So in practice, very difficult to access some service that, in theory, people should have access to. And I don't know if that will be the case for euthanasia, but the reason I'm mentioning this is that it's hard to tell whether and when an obligation falls on the profession as a whole or on individual doctors. Because if you have this type of situation, you might say, well, then the obligation is on doctors, not on the collective. Because if the obligation was on the collective, then we have no way to control this kind of the ratio between objecting and objecting doctors. But also the other problem is that there may be issue with fair distribution of burdens and responsibility within the profession. Again, I'm talking about the case of abortion because it's where many legislation already exists. If too many doctors object to provision of abortion, for example, then those who do not object have to do more of this, which I think is not a very pleasant thing to do. And we might have the same situation with euthanasia law. So there is a question here about what counts as a professional obligation once you operate within a legal framework that allows people to access certain services. And the question really is one about professional obligation of healthcare professionals like doctors, not necessarily only doctors, so other professionals who might be involved in providing assistance in dying. Now, if you think about freedom of conscience, so there are two things that you might want to say. So first of all, you might want to say, well, if there is such a thing as freedom of conscience, then it doesn't make sense to say that there is a professional obligation to provide euthanasia. So that's not what the law should say. So, or you may want to say that, yes, there is a professional obligation, but some practices, some procedures are so special that exemptions are allowed. So on the first example, on the first case, you say, well, it doesn't make sense to say that doctors have a professional obligation to provide euthanasia, but also they are free to not to do it, because that means they don't have an obligation at all. So let's stay with this for the moment. So will doctors have a professional obligation to perform euthanasia in a context, say in a country where euthanasia is legal? So I should say, I'm not saying anything here about whether or not euthanasia should be legalized. So what I'm talking about is, assuming there is a law that authorizes euthanasia, what a good law would be. And I don't need to tell you anything about what I think about euthanasia. I may be for or against it. It doesn't matter really, because what I'm saying is that suppose we have this law. What obligation should there be on doctors? Should there be conscientious objection? So the question about professional obligations is very complex because what counts as what are doctors supposed to do as a matter of professional obligation? What counts as a professional obligation? And there are many views, many theories about that. It's not as straightforward as you might think, especially when it comes to controversial practice, because of course, if it comes up to things about like treating diseases, for example, it's pretty straightforward. Yeah, doctors should treat diseases as best as they can, not harming patients, benefiting patients as much as possible within the limits of scarce resources, so fair allocation of resources. There are guiding principles. But for controversial cases, what counts as good healthcare? So I said at the beginning that a good euthanasia law is a law that is consistent with good healthcare. What counts as good healthcare? And therefore, what do healthcare professionals have an obligation to do? Because healthcare professionals have an obligation to provide good healthcare. Is euthanasia good healthcare? Again, people will disagree, but the question I'm interested in is what counts as a good healthcare, and therefore what counts as professional obligation. So there are at least three ways of reasoning around this. So one is to say that good healthcare and therefore professional obligations is determined by the law. So whatever the law says is what doctors have to do. So if you're a doctor operating in a country where abortion or euthanasia are legal, then your professional obligation is to do what the law says that patients have a right to get. Because you exist, because the law says this is something that the medical profession should provide. So it's not that I'm a philosopher. It's not that I can provide abortions or help with euthanasia. If I help someone with euthanasia, I will go to jail. But the point of euthanasia law is to say, well, there is a special group of people, we call them doctors, who can do it now. So I cannot do, if I do it, it's murder. If a doctor does it, it's legally permissible euthanasia. So, and this raises a question about what the healthcare profession is for. So where do professional obligations come from? One argument here is that, well, the healthcare professionals operate under a regime of monopoly, so they are licensed by their society to provide certain services. They have a monopoly over the provision of certain services that other people cannot provide. And this creates obligations on doctors. So doctors ought to do what the society they operate in expects them to do. If the society decides that abortion or euthanasia should be legal, that's what doctors should do. And then you might disagree with the law, but then one might say, well, the solution is let's change the law, let's campaign to change the law. There is a political debate about that. So what activist organizations try to do is to try to change the law. So some activist organization will try to change the law in one way, and then there will be other organizations, other people who have the political means to challenge that. So that's part of the democratic practices. But once society decides, that's what they expect doctors to do. That's one way of thinking about it. A second way of thinking about it is, well, what counts as a professional obligation is what your professional organizations say, professional bodies say. I don't know, the American Medical Association, the British Medical Association. There is a question about what counts as the relevant body. But the issue here is, well, once you become a member of this profession, there are ethical principles and guidelines that regulate the profession. And that's what your professional organization say you should do. So generally, professional organization would say, well, you have to operate within the standard of good medical practice. In the US, for example, the American Medical Association says that abortion can be consistent with good medical practice. So one might say, well, if that's the case, and people might want to challenge that, but if that's the case, then you as part of this profession, you just should do it because you do whatever is part of good medical practice. Again, this is a second option. One interesting thing is that these two things might conflict with each other. So the law and professional guidelines might well be in conflict with each other. For example, in some US states now, abortion is not legal anymore, but it's still the case. The American Medical Association says that abortion can be consistent with good medical practice. So there seems to be a tension between the two paradigms here. I don't know how the tension should be solved. My point is that there is a question here to be asked about what counts as a professional obligation. And the third model, so I said the law, professional organizations. The third model is simply, one may say, well, professional obligations are whatever good medical ethics says that doctors should do. So there are people thinking about the ethics of medicine, healthcare. So doctors should do the ethical thing. Now, the obvious question is, okay, who decides what the ethical thing is? Because there are people like me, Cesar, Dominic, paid to do, or Eloise, paid to do medical ethics, but we don't agree with each other. So it's unclear what good medical ethics is. But some people say, well, whatever the ethical standard of the profession is, that should be what doctors should be obligated to do as a matter of professional obligation. And if that's their professional obligation, then that's what the law should take into account. So I don't know which of these three models is the right one. I think this is the type of conversation we should have. And that's a conversation about what counts as a professional obligation. And whatever we decide, a good euthanasia law should include those things, because a good euthanasia law should be consistent with professional obligations. Now, the issue of conscientious objection here, if we assume that there is this idea that doctors should do whatever falls in their professional obligations. So conscientious objection is a bit of it's unclear how it fits into this picture, because either you say, well, there is a fourth model, which is conscience. So professional obligations are defined, among other things, by doctors on conscience. So if a doctor conscientiously feel that, for example, or thinks, I shouldn't say feel, because, or thinks or reason that euthanasia is not part of the job, is not permissible, it's problematic, then they should be allowed not to do it, because conscience, their own values and principles, define professional obligations. Now, this is a bit problematic to sustain, because, first of all, because different doctors will have different principles, different consciences, so you might create a situation of a bit of anarchy where everyone decide what they don't want to do. So it's very difficult to fit conscientious objection within this framework. So, but then the alternative will be the second one I mentioned earlier. So there are professional obligations, however we want to define them. So either it's through the law, through professional code of practice, or through good medical ethics. So these define what professional obligations are. If there is a law that allows euthanasia, then there is a professional obligation to perform euthanasia on doctors. That's it. That's the professional obligation, clear, defined by the law. But one may say, yeah, but some things are a bit special, euthanasia, abortion. So there is an obligation, but there is also some arguments, some grounds for exemption from the obligation. So that doesn't mean that there is no obligation. There is an obligation, but there is a special justification for exempting certain doctors. And normally you would have this kind of argument in the case of euthanasia, in the case of abortion, in the case of in vitro fertilization sometimes. Sometimes people make this argument in the case of transgender care. Well, the fact that I'm listing these things and I'm not sure where to stop already suggests that there is a bit of a problem here, because one argument against this idea that there is an obligation but there is a ground for exemption is that, okay, where do you draw the line? It seems a bit unusual for a profession, well, it is unusual for a profession to allow this scope for freedom of conscience within a professional context. It seems that healthcare is a bit special, because in every other profession that doesn't happen. So if I, as a profession, if I teach, and suppose that I am opposed to the theory of evolution for my own religious reasons, and have to teach a biology class or a philosophy of biology class, more likely than what I do, then I cannot say, well, I'm not going to teach that because my conscience prevents me from doing that. Why is healthcare different? So why, two questions. First is, why is healthcare different from other professions that don't allow scope for conscience? And secondly, within the healthcare profession, why are certain procedures special? Abortion, euthanasia, IVF, transgender care. What about vaccination? Suppose I'm against vaccines for, well, there's some vaccines for some religious reasons, for example, like some people are, but I'm also a doctor, and I say I'm not going to provide this vaccine for my conscience. Suppose I am a Jehovah's Witness and I'm against blood transfusion, and I say I'm not going to provide blood transfusions. Then people might start having problems there. But my question is, why would euthanasia be different? So is there a strong enough ground for freedom of conscience within the healthcare professional that doesn't draw arbitrary lines among professions and within the profession among different practices? And I don't know. That's the challenge, because I said earlier that a good euthanasia law, well, I said earlier that compromise might make a good euthanasia law. That's the argument for allowing conscientious objection. But then when you start reasoning in terms of the principles at stake here, it's unclear why conscientious objection should be allowed in the healthcare profession at all, and in specific legislation like euthanasia or abortion. If we have agreed as a society, and you might disagree, some people here might disagree on that, but if we have agreed as a society, or as a medical body, a professional body, or we all do in medical ethics, if we agree that euthanasia is good healthcare, that is, it should be provided, Because I don't think any euthanasia law would say, well, euthanasia is not good healthcare, but we should do it anyway. I suppose that if it gets approved, it's because euthanasia is good healthcare. It's very unclear to me why there should be a conscious clause, except for reasons of compromise. Well, it makes it more politically palatable, easier to pass. If that's the reason for having conscientious objection in a euthanasia law, that's fine, but then you need to bear in mind that many people would disagree with that. So to many people, that's not a good compromise. To many people, there shouldn't be any euthanasia or any medical assistance in dying. So maybe that's a compromise that will satisfy some people, not everyone. More generally, it's a question about the value of this type of compromises in legislation. But to me, the main point here is we need to clarify, first of all, why we would want a conscientious objection clause in the legislation. Because even the talk earlier, so you're of course very much in favor of euthanasia, but you say, yeah, but doctors can be exempted if they want to. And I'm curious to know whether it's because that makes it easy to pass the law, it's a good compromise, or because there is a principal reason. Because the argument in support of euthanasia law might be different depending on which way we want to go. And that's important for public discussion. So we want to present a proposal for a legislation. That's about euthanasia in Mexico. It's about the assisted dying bill in this country, which as far as I understand is meant to include conscious clauses. By the way, I was listening to the news this morning. The assisted dying bill was in the news at BBC Breakfast this morning. It was interesting because I was talking about it today. And they said the word kind of, the law was stalling somewhere in the parliament and I don't know where. It's interesting because last year, it seems at some point this law was about to become effective, to be approved, but it's still there because, yeah, it's probably a long process. But because the discussion is still ongoing and there is still scope for this type of discussion, we want to have clear in our mind why, if and why we want, first of all, an assisted dying law, and secondly, if we do it, why we want a conscientious objection clause in it. If it's a compromise, I don't know if it's a good one. That's also is a question of what kinds of good compromise. So I'm happy to stop here if that's okay, and then we can have some time for discussion if that's okay. I hope that was clear enough. Sorry, I didn't use slides because my slides were not too good, I suppose. But happy to talk about any of these issues. Thank you very much.